One.
Good morning. We can start for.
Uganda versus Colonel Retired Dr.Kizza Besigye, Obedi Lutale, and Captain Dennis Olla.
Please worship. Richard, Chief State Attorney. Together with my young friend, Joseph John Hendo, also Chief State Attorney, appear before prosecution. You have this person in court, and I'll let my senior colleague, Obedi Lutale, to introduce the defense.
Please, Your Worship, my name is Obedi. Appear together with my learned friends. That is Dr.Kizza, Wanda Samuel Loman, Uniria Escopia, Kato Musime, Bayan Winawe.
The name is
Bayan Winawe. Chintu Mike, Farouk Kamrigen, Second Jacob Abubakar, Cyrus Oguru, Ato Wilson, and the Hafswa Tobias. There is a representation for FD. Not yet, not yet. And Your Worship, for the state, try to register our concern. Some of our colleagues are not here. some of our it's part of the defense team is not here, Your Worship. Reason we got very short notice because we received the production warrant when it was coming to 6 p.m. yesterday. And the team leader, that is Senior Council Nakawa, had just been coming to Nairobi. She was here on Wednesday. We requested the sitting magistrate to accommodate us this week, either yesterday or today. I said, the diary of the court is full, and the instruction we had was captured this matter to early June. We needed an he started his gun and said there was no way this matter would be would be fixed again this week. So that would have enabled our senior colleague Nakawa to stay. If indeed Your Worship had been accommodated for this week, she would be here to lead the team. Now, shortly after she had returned to Nairobi, we get someone's rather production number. And to make matters worse, Your Worship, we don't know why we are here. We have no idea. We could not even prepare anything. This ambush, total unacceptable, Your Worship. We don't know how court was moved, because there must have been a formal application moved court. We should production warrant, either by letter indicating the reason why court should be convened. Because the matter was at the 29th next week. So Worship wanted to be on record that particular matter, that this ambush is totally unacceptable and we take exception to it. Related to that, Your Worship, again, the atmosphere in court is not conducive for dispensation of justice. Your Worship, under Article 28 of the Constitution, one of the key tenets of fair trial is public hearing. Public hearing. The atmosphere, what environment you watch, is not in any way concomitant with the dispensation of justice. On Wednesday, Your Worship, we struggled to get at least an opportunity for the loved ones of their Tuesday persons to have an interaction. Even after it had been granted, we had to go through rigorous processes of realizing that constitutionally guaranteed right of access to loved ones within the precincts of court is the type of the prisons authorities here were to watch, restrictive. Even after the court given issue that we should have that right, the opportunity to interface or interact the accused persons. And shortly after that interaction, some members of the public were arrested, actually were kidnapped from the precincts of court. These were Katongole Uma and Kamira Abdul. They were picked by plainclothes operatives who could not be easily identified. And the very best I can describe them as because you take charge of the court premises so that members of the public who have a right to participate in the court proceedings, witness the court proceedings, who enjoy their rights without any undue interference or harassment or persecution. And finally, Your Worship, before you stepped in here, there was a hidden scene in this court. There was a scene here where members of, because he belongs to a registered party, he's a national leader, and there are people who are interested in these proceedings, who want to attend. And this kind of treatment is making it difficult for people here to witness the court proceedings. And I was telling you this morning, there was a scuffle, there was a scene here as security operatives. We are unleashing terror and brutality against law-abiding citizens who are here to witness court proceedings. We therefore pray that you should be pleased to issue directives and orders that will guarantee protection of the rights of members of the public who have got the right to be here. We do so pray, Your Worship. Again, for the record, Soka Simon for FD is with us. So much.
Worship, I want to emphasize that Honorable Karua Martha, Senior Counsel, it is illegal and violated the right to fair trial contrary to Article 28, Clause 1, as well as Clause 3, some paragraphs D and C. And we are making this complaint not only pursuant to the Constitution, but also the relevant sections of the Human Rights Act, namely sections 7 and 11. But because, Your Honor, this is a non-derogable right under Article 44, paragraph C, I think this court should be busy so that this court can be guided from similar gimmicks, repressive gimmicks by the state. May this be the last time.
Just.
Yes. So that this honorable court can be guided on how to handle similar gimmicks by the state, designed to choose lawyers for their choosing. By orchestrating ambushes in the forms of impromptu trials, impromptu appearances, court appearances like this one. This is an impromptu court appearance because even the lawyers in Uganda, some of them asked to respond to this production warrant. Some of them, I had to call them and they were asking oblivious of this policy. So, in order to enforce Article 28, we are praying that this matter be referred to the High Court pursuant to the Human Rights Enforcement Act, sections 7 and 11, so that this fair hearing, this egregious fair hearing infraction by the state is addressed once and for all, because it is not the first time that the state of Uganda has tried to technically, but of course, progressively exclude Honorable Martha Karua from representing her clients in Uganda. The first initial attempts were to deny her a PC. The third was to delay it. The last time she got it, she presented it when we appeared for the first time, and now when she needed it would not be here. The state claimed in open court that they would not have any time this week.
But I think you should be the matter to address.
Let him submit. Let him submit. Proceed.
My Lord, I will put rest that point here and emphasize the second point of we are not safe in this court for you, both as lawyers and as members of the public who follow these proceedings. We need your protection from wounds, some of whom are in court now as you write. In that corner, some of them are there. Some are in that corner. So, they are under whose corner, Your Honor, includes afterward arresting some of these people here. They are under oath in the nominous conduct, include arresting members of the public from here. They don't even wait to get out of court premises. They arrest Ugandans in court premises. It's about time judiciary protected Ugandans, because courts are sanctuaries of justice. They are not scenes of arrest. They are not torture chambers. But even this morning, there were blows in this court before before you started, before court started, because there are some fools who believe that they can come to court and not be filmed.
Don't use that language.
Most of that. There are some ill-educated persons, Your Honor, who are oblivious and ignorant about the right to public hearing. They think that they can be here and be protected without a court order. It is that level of ignorance that we have to confront every time we come to this court. Once again, that atmosphere is not safe and we need the express protection of this court because that does not require high court. It's not it is something that court can use its inherent power to defend. So great. I conclude by reiterating the prayers of the senior counsel.
For those taking recordings, ensure that at least you don't capture me. We proceed.
First of all, Your Worship, senior counsel raised the issue, senior counsel, that when this matter last came up, they prayed for today. Or yesterday, which is very true. I wish to add that even prosecution wanted yesterday or today. We never paused that anyway. It is upon that background that we moved this court. Prosecution moved this court. By way of a letter, which is on court record, to have this matter entertained today. It's also true that there was served yesterday. Be here. That also speaks to the courteousness of the prosecution. Because this is a prosecution's case at this level. On the issue of a senior counsel matter, prosecution is not going to be held back because of the absence of senior counsel matter. Should be ready to be present in Uganda full time. Because we shall not wait, we shall not work according to her schedules. That we're here waiting for counsel crew and prosecution is waiting. She cannot move her diary. What she has to do is that just make sure she's present all the time whenever this matter is coming up.
But we really appreciate the right of the accused persons to be represented. But despite that, we cannot be held back, and it cannot be a reason to even advance before this court. Because she never even informed that she's a resident of Nairobi. Besides that, we all respect the senior counsel, the years before, and other lawyers who are before this court, whom we believe represent the accused person ably. That is not to say that we choose who represents them, but our argument is that they are fully represented. And therefore, that cannot be a reason even think of referring this matter to the High Court. But even the record is very clear. This matter started on the 21st of February 2025. Senior Counsel Martha came in recently before this court. Does that show that the accused persons were not ably represented before? Does that speak to that? She appeared only to introduce and say a few things which were not even relevant. Does it mean that I withdraw that? I can withdraw that. Allow me to proceed.
No, you with the process without apology.
Let me proceed.
So it's fine.
Let me proceed. I have already withdrawn. But my argument is that the accused persons have been represented all through, and therefore the absence of senior counsel Martha should not be an issue and cannot be used as a basis to have this matter referred to court, because there's nothing available for a high court to hear in that respect, because this is a preliminary trial. It is not a substantive trial. We therefore invite court to treat that application by my colleague as redundant. It is actually aimed at wasting this court's precious time. And prosecution has been on record, Your Worship, previously for lamenting on how defense is investing in wasting time in this matter. Your Worship, we are not, as prosecution, aware. We are not aware of the previous arrests which were made. I heard my senior colleague Elias before to say some people were arrested. Within the court premises. Your Worship, prosecution does not support that. But we are not aware as prosecution in that respect. And prosecution is also not aware of the scene that happened in court this morning. And we do not know who was part of that scene and not. I don't know whether my senior colleague submitted an effect that is a statutory office against a court attendant or a court user. With that, we do not know. And I think I pray that court considers that as redundant, although it is imperative to emphasize the point of maintaining security and order in this court, in order for all of us to have a proper environment. My colleague Kizza alluded to the fact that lawyers and the public are not safe. But if anything of the sort happened, it is not something that prosecution supports. The prosecution supports the rule of law at all times. But we also appeal to the court users, other court users who are not security officers, to ensure that they behave because you have been singing here. We have not complained. We have been singing how Billy Funka will die, how his wife will die, and how his children will die. So we are calling upon your worship. It was on record. It has been captured. So we are calling upon that much as defenses are making on that, they should also prevail over their own people. They should make sure that their house is good. Because they came here and sang those songs which are for the accused person, we have no problem. But when you bring in the songs of the president, Muhoz, and then you bring in Billy from culture, who is not political in any way, it's not good, especially for the court users. I shouldn't have brought in that if council hadn't brought in that issue. The safety of the lawyers. They are also not safe. Therefore, Your Worship, just to wind up that, is that the accused persons are ably represented in court. You can imagine this fleet of lawyers, only to claim that the only person who is going to move this court is Martha. Led by senior counsel, one of the best lawyers in town. I grew up admiring Lord Mayor. There's nothing to refer. The accused person's right to representation is fully guaranteed, as it is in the Constitution. We therefore pray that this court overrules the defense and the prosecution submits as to why this matter was called today. Because we are ready to proceed. Submit.
We have a brief request, Your Worship. One, on the question of the state moving this honorable court to secure the production warrant, that there is a letter on record. It's not a profession for one to write to court and not share a copy of the communication you have filed on record with the opposite side. Very unprofessional. Up to now, up to this particular moment, Your Worship, they have not been given, have not been favored with a copy of that. that shouldn't be taken lightly. And it's not a favor. It's a right. And whichever reading you put on record, have a copy of the opposite. It's a command of it. So we are really taken aback by that submission. It shouldn't have come from a chief state attorney. That they've moved the court and they never served us. Stand up beside your worship. Secondly, your worship, it insinuated that indeed actually they had no objection to the adjournment of this matter this week, actually that they were in agreement with our prayer that this matter be fixed either yesterday or today. I hope it is also in agreement with the reason why we moved the court to have it heard today. Because the reason we wanted this matter to be entertained yesterday or today is on record, well captured on record. To give effect to the letter and spirit of Article 23, which dictates that once an accused person has been on remand for a period of 180 days, the next course of action will be mandatory bail. So if that is the reason we are here and is in agreement with that, then you have no problem. If we are here for a different reason, and that he moved the court to make other prayers, we have issues with that. If the court was, if this session is about that application, and the accused persons be released, because they have spent more than 6 months on remand, and the command of Article 23 is very clear, read together with Section 76 of the MCA. Your worship, if I may, for the record purposes, read this section 76, restriction on period of trial remand. If an accused person has been remanded in custody before his or her trial commences.
But Your Worship, before my senior colleague, without respect, is raising new issues. There's nothing like that came up. We never talked about that application is talking about. Neither did he even bring it up when it was actually making his first submission. So I think it is my submission that is irregular. Let him stick to my responsibility.
Your worship, this is not a LC. There are procedures, there are rules. If I may be permitted to make my submission, and if you so wish to respond, you will know what to do. You can apply for leave.
But you cannot raise new issues when I'm seeing this.
It is fine. Let him submit, then leave it to court.
Your worship, I was reading that particular provision. If an accused person has been remanded in custody of the field before his or her trial commences, A, in respect of any offense punishable by death, for a continuous period exceeding 180 days, or B, in respect of any other offense, for a continuous period exceeding 60 days. The magistrate before whom the accused person first appears after the expiration of the relevant period shall release him or her on bail on his or her own recognizance, notwithstanding that he or she is accused of an offense referred to in section 75, and so on and so forth. It continues. Unless, maybe let me complete it. Unless A, he or she has prior to the expiration of that period been committed to the High Court for trial, or the magistrate is satisfied that it's expedience for the protection of public that he or she should be released from, and so on and so forth, Your Worship. So the reason we are requested for this day, Your Worship, that's what I was justifying, is to respect, give protection, and to enforce this particular provision. Section 75, 76, read together with Article 23 of the Constitution, because they had spent more than 60 days, more than 180 days on remand. That is 6 months. And the command of this particular provision that once that period has elapsed, the magistrate, before whom they first appear, before any other action is taken, it's the issue of the release which has to be considered. Once the period of 6 months has elapsed, the first appearance before magistrate is about this. So we cannot do any other business today. And that is the reason we are asked court to accommodate that this week. I am glad he said he was in agreement with that. So if that's what brings us here, we are ready to proceed and make our case. That's the argument I was making in response to the issues that are raised, that he was in agreement with us for a fixture of today. Then about senior counsel Martha Karua not being part of the legal team today, it's very, very absurd to hear the state attorney make such a wonderful statements. And we take exception that our presence here is of no relevance, is inconsequential. Your Worship, the command of the Constitution is you open the provisions of Article 23 and Article 28. The liberties of an person choose their lawyers. It's well guaranteed under the Constitution. It's not about the competence or incompetence of those who are here. No. And the court wouldn't delve into that. You say, are those who are here are competent enough? No. It's about the right of an accused person under the Constitution to choose their lawyers. It's about giving respect to that person. Enforcing it. For heaven's sake, the accused persons are not about to disclose the reasons why they chose senior counsel Martha Karua to lead the team. And the state does not allocate themselves that duty, making a choice for them. To suggest that Martha Karua should stay here permanently is equal outrageous. It's on record she was given a license to handle only one case this week. It's a matter of logic. I don't even cite any law. It's a matter of logic. And the person who is outside the jurisdiction of this court cannot stay here to handle a case which is not being heard on a daily basis. And the reason we had asked court to adjourn to either yesterday or today, it's a question of convenience. We thought this is just a simple matter. It's basic. One would appreciate it. But one will not stay here and wait until 29 when you are a resident of Nairobi. That is outrageous, with all due respect. Then, finally, on the question of singing, you know how it is future is here. Your Worship, before court commences, this is a court meeting. Court means the setting we are having right now. No one, no court in the garage has attempted to sin in the court or before court. Here come, you're attentive, you're listening to the proceedings. I know of no law that prohibits anyone from expressing themselves before an empty court. I am talking about a court. A matter which is political in nature. Definitely you would expect it. It's no way you're going to divorce politics from a matter which is politically motivated. That we have sung about him, about Museveni, Muhoozi. No one can sing about it. I mean, as long as it doesn't offend the law. So you worship God. If one say, look what we will done, that's a given. That's a given. It's a divine ordained that all of us shall die. But if it offends the law, then there are procedures you have to follow. Under the law, you don't simply use wounds, hoodlums, to kidnap members of the family. No one has been charged with any offense. No one has been in any way presented before court, here or anywhere, in relation to what you are talking about. So you just pick people, brutalize them, and dump them the way you deem fit. The worship, God shouldn't tolerate that. So, in a nutshell, the worship, we reiterate our prayer that you be pleased to grant the religious we sought, but also to permit us to proceed your worship, make our prayer for the liberties of the accused persons under the provisions of Article 26, 23, and Section 76 of the MC. Article 23 of the Constitution and Section 76 of the MC. And the state shouldn't be allowed to proceed with any other matter apart from this issue. That is our prayer and worship.
Your worship, I reiterate the submissions of my senior land colleague, especially the prayers bit, and I want to emphasize 2 points. One, it explained about the nature of this being a preliminary trial. That is a given, no one is denying it, but even at the level of a preliminary trial, the right to fair hearing is sacrosanct. It cannot be suspended by an overzealous prosecutor in a case that is nothing more than political persecution and judicial harassment of a hero of Uganda. I want to also go specifically point number 2 to Section 7 of the Human Rights Enforcement Act, which reinforces Section 76 of the MCA, that my senior brother alluded to. I will emphasize there are just a few subsections. Section 7, subsection 1 is succinct, where in any proceedings in a subordinate court, any question arises as the violation of a fundamental right of freedom, the magistrate shall refer the question for determination by the High Court. That is subsection 1. Subsection 2, where a human rights matter arises in any proceeding before a magistrate's court, the court shall immediately stay proceedings in the matter and first determine the human rights issue raised. And especially then subsection 3 relating to the liberty of the accused. A magistrate presiding over proceedings referred to above may stay the proceedings until the reference is determined and may, in the case of a criminal trial, grant bail the accused person. Of course, 4 says that the court shall dispose of the matter in accordance with what the court says, and the High Court is also given a timeline within which to operate according to subsection 5. So everything points to that today it's only the bail of the accused persons that this court can handle, and that the court's hands are tied. 1, to refer the matter to the High Court for fair hearing, and as they refer it, to grant bail in the terms and following section 76 of the Magistrates Court Act. I will not respond to the whole about of the prosecution.
Your Worship,
Just a moment. Let him access the meeting.
Your Worship,
It's okay.
and a little more emphatic. First, I associate with the submissions of Lord Mayor Elias Lukwago and the submissions of Dr.Kizza. The state informed court that it was an agreed position on the 21st. The Worship, on the 21st of May this month and this year, the sitting magistrate informed court that he only had 2 dates of which he was guided to adjourn his case. That was on the 2nd and the 5th of June. The defense prayed for today. It was the decision of the sitting magistrate that the matter be adjourned to the 29th of May. The state has informed that there is a letter on record. I want to be clear on this, that I do not and we do not have a copy of that letter. But it is the command still about legal representation and adequate facilities to represent. I don't have the letter. This speaks loud that I do not have adequate facilities for fair representation of A3. It is just fair and in the interest of justice that the matter be adjourned to any other date. If you incline not to adjourn, actually when they informed me that Ola was coming to court, I thought I was coming to take Ola home. If it is the case, I will be happy to take Ola home. Short of that, Your Worship, I pray that the matter be adjourned to the date where I can adequately prepare to represent Ola today. As it is today, I'm not ready to represent him. For I do not know why we are here. I was ready for the 29th to represent Ola adequately. I simply want.
Your Honor, Joseph Kyomuhendo, Chief State Attorney, and with the leave of this honorable court, we wish to reply to the new issues that have come up.
It is granted for you to respond to only the new issues that have been raised.
Much obliged. Your Honor, in regard to the period spent on remand, to the best of our knowledge, the accused persons appeared before this honorable court on the 21st of February 2025, and today is only the 23rd of May 2025. 21st of February 2025, and today is only the 23rd of May 2025. And an arithmetic calculation leads us to a period of 4 months, and not the 180 days that our land. My Lord, 3 months, and not the 180 days as alluded to by our senior land friend, Honorable Kwame. Okay. Even if the accused persons had clocked the mandatory period, Section 76 of the Magistrates Courts Act should be read mutatis mutandis, the bail guidelines. And my Lord, according to guideline 99, which I'm going to read out verbatim, mandatory bail for offences triable by High Court and Magistrates Court. Where an offence is triable by the High Court as well as by the subordinate court, if a person has been on remand my Lord, Your Honor, sorry, it is guideline 10. According to guideline 10, where the offense before this honorable court, where the offense is before this honorable court and is triable by the High Court, the application can only be made before a High Court judge and not before you, Your Honor. In other words, the issue of mandatory bail in a capital matter cannot be raised before this honorable court. My Lord, we pray that you dismiss. We pray that you dismiss or disregard our senior land friend's prayer in regard to entertaining the bail application, my Lord. We so pray.
Just add on. That issue of mandatory, I think my senior colleague just brought in as a bonus for ahead time, because it was not an issue which he brought in the first place. Secondly, the defense has no duty to dictate what this court has to do with the prosecution's case. It was erroneous for my senior colleague to submit that they can only allow anything to do with the application for mandatory period of time. It is the prosecution that moved this court to have the matter in court today. Before we even actually bring to the attention of court as to why we made the application, defense. And this is what I've been saying, Your Worship, that we are being arms twisted on several occasions. And this is one of the ways. We have not made clear why we wanted to be in court today. Defense is dictating. This is the spirit which defense is using to ensure that this matter is not heard at all. We therefore invite this court to, first of all, only regard the reason as why we made the application and disregard the application made by my senior colleague. This court should be heard or should be seen moved by prosecution on the reason as to why this application was made, the protection warrant, to have the matter today. Otherwise, we shall waste that entire day speaking about that. That issue can be brought when the prosecution is actually unveiling the reason as to why they paid for the production warrant. So,
This is Your Worship. Because now they have delved into the base of the application we are going to make for mandatory release. For us, we are making a case to be permitted to proceed to make the application for mandatory benefits. Because we had raised the issue of appearing here without court being formally moved. Now they indicated that what is what we moved. And we said, okay, if we are here to entertain the application for mandatory bail, we are ready to proceed. And we are waiting for the pronouncement of the court of that matter that we proceed with the application for mandatory bail, then we make it. Now they appear to have responded before we made it. May we be permitted now also? I don't know. If we would be given it because they are raising issues of regulations, we need to address all of the issues of regulations.
Okay. I note that the prosecution and the defense has raised several issues. Which court has to address? Can I make a ruling on this as it is?
The family is made. They have raised issues to do with the guidelines, the practice guidelines of the chief justice. And if court is going to make a decision on the same, it would only be fair that we raise some issues with regard to that particular matter, if it's only that issue alone.
Council, you said that you have not yet made your application.
Not yet.
Can I rule on what is here, bearing in mind with what you submitted?
So better listen about this. The number is already written there. Subscribe, like, and comment, and we make it happen.
Order.
You better tell your friends to subscribe. Better tell your friends to subscribe. Subscribe. We are waiting for a ruling, a simple ruling. Subscribe. The number jinawa wadewa naye mutekeko ya MTN kila angamba mwe number egamba please wait. Tokoa kila. Keep pushing.
This is Aroni. I note that the prosecution and the defense have raised several issues and lengthy submissions on the issues raised. The issues raised majorly are in regard to legal representation as provided for under the Constitution. The defense has raised an issue that the two persons are represented by Counsel Martha Karua, who is currently in Nairobi and ought to be here to represent her clients. This court is mindful of the right to legal representation as provided for under the Constitution of Uganda. The accused persons are before court and are ably represented by lawyers, although they state that Counsel Martha Karua is the lead counsel. Whereas this court appreciates her role as lead counsel, I believe that the team of lawyers in court present can ably represent the accused persons for today's hearing. This court thus believes that the accused's right to legal representation is guaranteed. This court thus finds no basis to refer the matter to High Court under the Human Rights Enforcement Act. Counsel Rukwago has submitted that they are in court today to make an application for release of the accused persons, and as such, the submissions made by the prosecution are done prematurely. The accused, having appeared in court on a production warrant, the prosecution should proceed to make its application or proceed with the production warrant, the reason why it was issued, and thereafter the defense may make the prayers they intend to make in regard to the liberties of the accused persons. Yes. Just wait.
Your Worship, my lawyers don't have instructions to proceed with the absence. I don't know where that leaves us. Because the appointed the Honorable Nakawa come from that far. I'm concerned with the competence and availability of our current team that we have. But she has a special role for me. That we have had to incur that great cost. Get her here each time. Follow up these case. And as the lawyers have immediately pointed out, she was here. We were ready to proceed. Only that it was not really possible. We are now informed, I was informed at 7 p.m. last night, that there is a hearing that the production warrant has been received. We need so our lawyers, some of them are not. So, Your Worship, our lawyers definitely don't have instructions from us. Proceed in the absence of our leaders.
Your Worship, as our client has submitted here, we act on instructions. Our former client. It's our client as far as the matter is concerned. But today, the matter where we have instructions is supposed to come out on office. So we are here on Wednesday this week, and that matter was adjourned. As for the proceedings of today, where we do not even have a copy of the letter, which is moving the court to proceed, where we have no idea as to the substance of what is going on. We are constrained in worship.
It's on record for the accused person, A1, A2, and A3 were in court. Just on record that when they were in court, Lord Mayor, Senior Lord Mayor, Upa, introduced himself and his entire group as lawyers representing the accused person. And the accused person was listening. submitting. If there was anything to do with not instructing them to do anything in the absence of Martha, then he should have raised it at that time. And then was Lord Mayor and his group holding out as lawyers for him? That is the question. How did they come to represent him in this court today without instructions? This is what we've been talking about, arm-twisting prosecution, delaying, frustration. And then they start lamenting 6 months. Prosecution is making a headway into investigation, it is expediting the process, defense is holding it back. And then they come and submit how the rights of the accused person have been infringed upon. I think this is a duty of both prosecution and defense to ensure that we have an expeditious process in this matter. You cannot cite other rights and then you leave the right to a speedy and expeditious trial, which we are talking about. In any case, there has not been any substantive reason as to why the absence of Martha can stall this matter. This is a prosecution case. Look like defense is taking it off. Now court has to dance to the tune of the defense. We are being held back. Court has already made a ruling on that. If A1 retired Dr.Kizza Besigye knew that he had that in mind, he should have raised it even before this court made that ruling. We are submitting that that is an abuse of the process. It amounts to an abuse of the court process, which is detrimental to this matter. And it is a submission that this court disregards that and we allow prosecution to inform court the reason as to why this matter is in court. First of all, this is at a preliminary stage.
Let me just stop right there. So I have made a decision, I have made the ruling, so you made the submission after my ruling. On the fact that there are other lawyers who can ably represent A1.
Your Worship, I myself am not a lawyer. I agree now. Your Worship, the matter was adjourned to Thursday, 29. So why we are here, we don't know. And that's the reason we raised and said, Your Worship.
can we be permitted to proceed with the matter where we have instructions? That is the application for mandatory bail. If court is not ready to entertain that application for mandatory bail, we have no instructions to proceed with the matter which is going to be resolved in the state for even a sake which is not known to us. And on that note, Your Worship, with all due respect, if you will permit us to withdraw from the bar and we proceed with the trial. We proceed with an accused person with our
Give us way.
this matter made 25 made 25 they are going out. That jump to 29. Prosecution moved the court 29th of May 2020 yesterday to have this matter counsel for everybody is in court. So in the circumstances, Your Worship, we pray that under section 132 of the Magistrates Court Act of 19.
So we intend to make an application for
Yes,
amendment.
exactly.
So if you intend to make an application for the amendment of the charge, it is only proper that since he says that we have a special attachment with Council Martha Karua, let Council Martha Karua be present when that application is being made. So that application will be made on 29 May. I hope it's clear now. So inform me of the council. The council will be here. So the matter is adjourned to 29 May at 9.
That is not sure. How are you, sir? Kasowanda wali ngato tujja nkyali ate nkyaliyo tizinsiina
basobola osalamu clips omumo
basalemu
let's agree with switch
nze nina abantu 5 kati nzijjako ki
ati bajja salamu
bajja salamu niyo mpozi nze tekuli bali bonna
kyemanyi totegeera kyenkugamba nakati
Thank you.
See, as lawyers, we have the instructions. And the instructions have to be specific on what to deal with. And when you receive instructions, you've got to, first of all,